Grand Prairie ISD made another legal move to fire its new superintendent. State judge rulings kept delaying the district from firing him, so now they're looking to federal courts. Fox 4's Lori Brown live at Grand Prairie with the latest. Lori.
Heather, it will now be up to a federal judge to decide if this case belongs in federal court or state court. All the while, the superintendent says he still hasn't been told who has made the allegation against him or what the allegation is.
So we don't see there being any basis for there being federal jurisdiction over these state claims.
Mary Nix is the attorney for Superintendent Dr. Jorge Arredondo, hired by Grand Prairie ISD June 24th and then placed on administrative leave just over 2 months later, September 4th. In October, the board was set to vote on whether or not to terminate his employment. But a judge intervened when Arredondo sued for breach of contract, violation of due process, and defamation.
If they're claiming that there is a basis for terminating him for cause, they have to, under the law, due process, right, under the Constitution, and under his contract, provide him with notice of what those allegations are and give him an opportunity to respond and defend himself.
In October, the board publicly alleged Dr. Arredondo violated a policy against discrimination, harassment, and retaliation called DIA.
I move to let the board officers move forward as discussed in closed session due to the violations of local DIA policy.
While Nick says Arredondo does not know who is making the allegation or what the allegation is, Arredondo's lawsuit says school board trustees Amber Moffitt and Emily Lyles questioned his justifiable decisions. The filing says, for example, they were unhappy that Arredondo reassigned a white female executive who had missed more than 20 school days the prior year to a position where her absences would not interfere with school performance, and with Arredondo's decision to hire a new principal for a campus which had an F rating for 2 years in a row. Instead of supporting Arredondo in his work to improve the district, which is what he was hired to do, Lyles and Moffitt began denigrating Arredondo and both made disparaging and discriminatory remarks about plaintiff's race, national origin, and language. They made it clear that they were not in support of plaintiff's decision to hire 2 Hispanic executives, and even asked if one was hired to be a chauffeur. Moffitt and Lyles have not responded publicly to those allegations. The lawsuit also claims that school board members committed defamation by stating Arredondo violated policy without giving him the opportunity to respond. This is what was said at the October board meeting.
But when someone, as you heard, violates a policy, we stand on policy.
Our position is it's defamation because he has not violated the DIA policy, and to say that he has is not truthful.
Grand Prairie ISD has argued in a court filing that the district has sovereign immunity and therefore the Texas District Court lacks jurisdiction. Nix believes the district's effort to move the case to federal court leaves her client vulnerable once again to being terminated. For now, Arredondo remains on paid administrative leave.
I think most importantly, Dr. Arredondo wants a resolution. He wants to get back to work and do what he was hired to do.
After GPISD's motion, the temporary restraining order preventing the district from terminating Arredondo is no longer in effect. Heather.